Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, you know, there is a lot of different ways that they're going to attack your Second Amendment rights. And one of the ways is not by directly attacking the Second Amendment. No, it's actually by directly attacking the First Amendment. Because why don't we just cancel anybody who wants to speak openly in support of their Second Amendment rights? What am I talking about? What I'm talking about is what's going on in our public education system. So for those of you who have children in public education, you may want to listen up. Here's the example I'm going to give you. If Gun Law Junior or Gun Law Junior decided to go to their public school and wear one of Dad's logos, what do you think was going to happen? Well, that's exactly what happened to a young girl in Michigan, and we're going to talk about just that. So today, let's spend a few minutes and let's talk about what could turn out to be a very, very important case. So let's geek out on the brief for a minute and let's talk about how schools are canceling pro-Second Amendment speech. What do you got there, man?
TacPack.
Oh, sweet. A TacPack? Nice.
Oh, what's a TacPack?
That's the new sponsor of the channel.
So what's in a TacPack?
Oh, what's in a TacPack? Well, here's the best thing. It is a monthly subscription of all sorts of tactical gear. And I mean, they got a lot of really cool stuff. The best part about it is that they actually have two separate subscription models. So they got their TacPack Standard, which ships at $59.95 a month. Best thing about that is it really has a value of about somewhere between $90 and $120. And then they got the TacPack Plus. Now that ships at $139.95 a month, but, oh, check this out. They actually have a value of somewhere between $240 and $300.
Wow, that's pretty cool.
Yeah, it's super cool, and here's the coolest part yet, because if you sign up right now for the TacPack Plus and you use the promo code GunLawYT, you're going to get an extra $60 everyday carry kit, which means that your initial investment for less than $140, you're going to be ended up getting over $300 worth of tactical gear. Listen, look at some of the cool things you're going to get if you subscribe to TacPack today. So get down there, check out the link below, make sure you use the promo code GunLawYT. Check out TacPack. Okay, America, the case that we are talking about today is the case of CS versus McCrumb. It is currently in the 6th Circuit Court of Appeals, originating out of the state of Michigan. Now, at the very beginning, I said, what would happen if Gun Law Junior or Gun Law Junior decided to wear one of those logos on some clothing, a hat, or something like that, and go to their public school? And the answer here in liberal King County, Washington, is probably not real good. We're going to talk about a very similar situation that occurred in Michigan. The plaintiff here, an underage young woman, so she goes by the initials of CS, goes to a public elementary school in Michigan. During their Spirit Week, they had a designated day known as Hat Day. So her family, which are all very pro Second Amendment rights, and their young daughter, who again is abundantly aware of where mom and dad come down on that particular issue, and she supports mom and dad, she decides to wear this hat to school. Well, of course, the school has a conniption fit, calls dad and says, oh, you know, I know it's hat day, but, you know, your girl's wearing kind of an offensive hat here, and so we need you to come with a replacement hat. Dad says, no, not going to do it, and away we go. The lawsuit starts. Now, just so you understand what's at stake here, the policy in which the school district used to enforce their subjective opinions on this reads as follows. Anything printed on clothing must not be offensive in any way. The building principal staff has the right to decide what is offensive, but some examples are words, slogans that advertise illegal substances, words, slogans that are racially or religiously offensive, violence themes, vulgar or sexual innuendo, etc. Well, CS, through the help of her father, decides to sue the school district saying, hey, my daughter was deprived her First Amendment right of free expression. The lower court, as well as the school district, completely disagreed and granted summary judgment against CS on multiple grounds, predominantly citing 3 reasons why the school district was completely appropriate in banning this. One, the existence of a weapon at all as an image equals a violent theme and therefore it is prohibited. Number two, another violent theme was come and take it, as they were worried that the kids might actually try to come and take the hat. And then third, in the catch-all, it was going to disrupt the educational flow. And that third one is the catchphrase, and the school district knew that they needed to cite that because all of this comes back to a huge Supreme Court case from the year 1969 called Tinker versus the Des Moines Educational School Board. Some of you may recall this case. You may have read about it in a history class. This is during the Vietnam War, in which students wanted to wear black armbands to protest American involvement in the Vietnam War. The school district prohibited it. The students then sued, and the court came back and stated that the students' First Amendment right of free expression had in fact been violated by the school district. And so understand that this case, and if you're struggling with these issues where you live with your children in their school district, this Tinker case serves as a backbone for this entire issue, and it serves as the backbone for the entire arguments on behalf of CS here. Under Tinker, CS's right to wear the come and take it hat is protected under the First Amendment. The First Amendment protects elementary school students, not just junior high or high school students, and there was not enough evidence of substantial disruption to allow the school to suppress CS's speech. Moreover, the district court applied the test for school-sponsored speech, even though the school officials failed to show the speech was school-sponsored. And so school districts cannot just ban this type of expression because they think it might possibly disrupt the educational flow, or that they themselves are mildly concerned that it may disrupt the educational flow. No, the Tinker standards actually require much more, including to justify censoring speech, school officials must be able to show that their action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. And as a matter of fact, the Tinker court carved out a rule to determine whether or not this speech is appropriate for the school setting. 3 specific categories of student speech that schools may regulate in certain circumstances. 1. Indecent, lewd, or vulgar speech uttered during a school assembly or on school grounds. That clearly is not the case here. 2. Speech uttered during a class trip that promotes illegal drug use. Absolutely not applicable here. And then finally, 3. Speech that others may reasonably perceive bearing the imprimatur of the school, such as that appearing in a school-sponsored newspaper. And listen, not only has the Tinker case been good case law now for over 50 years, but there have been many spin-off cases which took the reasoning of Tinker and expanded students' First Amendment rights. And those cases were also used by the plaintiffs here. And there is no exception from the First Amendment for speech that depicts weapons, as federal courts have recognized. For instance, in Newsom v. Abermalley City School Board, the Fourth Circuit upheld a middle school student's right to wear a t-shirt to school depicting the letters NRA and people pointing rifles. The student was told he could not wear this t-shirt to school because guns and schools don't mix, but the court disagreed. Tinker requires a specific and significant fear of disruption, not just some remote apprehension of disturbance. Oh, and then there are other cases that are almost directly on point with what CS is doing here, again using the Tinker reasoning, this one in New Jersey. Likewise, in New Jersey versus Sonnabend, the Seventh Circuit held that Tinker applied when a high school student wore a t-shirt to school that depicted a handgun, and school officials told the student he could not wear the shirt. As in this case, in New Jersey, the principal said clothing depicting firearms was inappropriate. But the Seventh Circuit concluded that an undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression. And so, parents, if you are struggling with this issue, understand, simply put, the rule of law here is, it is not enough for the defendants to have a mere desire to avoid the discomfort and unpleasantness that always comes with an unpopular viewpoint, or an undifferentiated fear or apprehension of disturbance. And of course, it is that mere possibility or mild apprehension of maybe possibly having a disturbance that the school board used in justifying the censoring of CS's freedom of expression. But as the plaintiffs correctly point out here, What they describe, of course, is merely a generalized desire to avoid unpleasantness and an undifferentiated fear. Exactly what Tinker instructs is not a valid basis for censoring speech. And then finally, the last issue they point out is this qualified immunity, because one of the things the lower court said is, hey, these are school officials acting in their official capacity, and therefore they have qualified immunity. But there is an exception. And the exception, of course, is if you absolutely positively know you are violating a constitutional right. And the fact that Tinker now is 55 years old case law, and the fact that there are multiple other cases out there, and the fact that the school district was aware of the exact reasons for which this young woman had chosen that, it had nothing to do with trying to disrupt the school, it had nothing to do with trying to intimidate or inject fear in anybody. It was literally showing support for a strong belief that her family held, that the willful violation of that obviously would pierce through any type of qualified immunity. Okay, the case once again is CS versus McCrumb. Like I said, it's before the Sixth Circuit Court of Appeals right now. We'll link up the plaintiff's brief down below so that you can geek out on it for yourself. Maybe you got more questions about this or anything else related to what's left of our Second Amendment rights. If you do, parents, pay attention. The information on how to contact Washington Gun Law is all down there in the description box. If you got an idea for a video we should be doing around here, tell us by clicking on that link right there and letting us know. It's probably going to be better than any idea we come up with. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.